In support of its goal to end discrimination against individuals with disabilities, the Americans with Disabilities Act, or ADA, prohibits employers from asking about whether a job applicant has a disability before making that applicant a job offer. In Harrison v. Benchmark Electronics, a rejected applicant claimed that his prospective employer's questions about his drug test results violated this prohibition. John Harrison was a temporary worker at Benchmark Electronics. At the request of his supervisor, Don Anthony, Harrison applied for permanent employment at Benchmark. Harrison agreed to take a drug test as part of the application process. Harrison's drug test came back positive for barbiturates. Anthony told Harrison about the test results. Harrison said he had a prescription for the medication, and Anthony told him to go get it. Anthony then called a medical review officer and gave Harrison the phone. Harrison answered several questions from the medical review officer while Anthony remained in the room. While in Anthony's hearing, Harrison told the medical review officer that he'd had epilepsy since he was 2 years old and that he controlled it with barbiturates. Anthony didn't ask any questions. After the medical review officer cleared Harrison for employment, Anthony decided not to make Harrison an offer. Anthony also asked the temporary agency for which Harrison worked not to send Harrison back to Benchmark. Harrison sued Benchmark in federal district court, alleging that Benchmark had made improper medical inquiries in violation of the ADA. The district court granted summary judgment for Benchmark. Harrison appealed to the 11th Circuit.